5 seconds to go. Start. We will now examine the FIR as well as other documentary evidences coupled with the oral evidence produced by the prosecution to examine if there is any relationship between the appellant and the victims to either enforce bonded labor or if he had advanced any bonded debt. In the FIR, though the name of the appellant is shown as the second accused, with the first accused being his deceased father, there is nothing as to how and in what manner the appellant is involved in the commission of the offence. All the allegations in the FIR are relatable to the appellant's father, and there is no allegation towards the appellant compelling any person to render any bonded labor or having advanced any bonded debt. In fact, nothing is attributed to the appellant except for mentioning his name in the list of accused. The absence of any allegations against him must be seen in the context of his submission from the very beginning that he is not residing with his father. It is his case that he is residing at Chengalpattu. We proceeded further and examined the evidence of PW1, the complainant. This witness made specific allegations against the father of the appellant for his abusive behavior. Here again, there is no reference to the appellant for having compelled bonded labor or advanced any bonded debt. PW3 Kuppan made a journal observation that the rice mill belongs to the appellant and his father. We will shortly be dealing with the evidence of the investigating officer in this regard in the context of his obligation to establish the co-ownership of the appellant. Before that, we may note that PW3 also fails to mention as to when the appellant compelled him to render bonded labor or any such forceful labor. The witness makes general allegations and uses the expression they, which is an ominous reference. At one place, the witness also stated that the appellant beat his father-in-law PW1 with a stick. The other witnesses do not corroborate the same, neither have they levelled any other allegation against him. So far as the district revenue officer examined as PW8 is concerned, he only mentions the raid conducted at the rice mill on the basis of a complaint, but does not mention anything about the appellant. Even the investigation officer examined as PW13 has nothing to say against the appellant. The reasoning adopted by the High Court that the rice mill belongs to the appellant's father and also that it also bears the name of appellant by itself cannot be the basis for convicting the appellant for commission of the offence under sections 16 and 17 of the Act. The conviction is a non sequitur and the name of his rice mill certainly cannot be a proof beyond reasonable doubt to convict and sentence him for 3 years. The High Court was examining an appeal against the acquittal. The principles governing consideration in cases of appeals against acquittals is well entrenched in our criminal jurisprudence. For the reasons stated above, we are of the opinion that the High Court is not justified in reversing the judgment of acquittal. Stop.